Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On January 18th, the court heard arguments in Cassirer v. Thyssen-Bornemisza Collection Foundation. Joining today to discuss this case in two parts is Professor Suzanna Sherry, the Herman O. Loewenstein Chair in Law Emerita at Vanderbilt Law School. This episode will begin with coverage of question and background and proceed in the second part to focused analysis of oral argument.
Thank you. The beautiful Impressionist painting is Rue Saint-Honoré, Afternoon Rain Effects. It was painted by Camille Pissarro in 1897, and it was purchased in 1900 by Paul Cassirer, a prominent German Jewish art collector. And in 1939, it was expropriated by the Nazis from Paul's heir, Lily Cassirer, in exchange for permission for her to leave Germany. She did leave Germany with some of her family members, including her grandson, Claude, and they both emigrated to the United States. Sadly, some of her other family members did not leave and were murdered in the camps. The Cassirers and the post-war German government lost track of the painting. Everybody assumed it had either been lost or destroyed during the war, although Lily and then Claude never stopped looking for it. But the painting had not been lost. Instead, it was sold to a California art dealer in 1951, and it spent the next 25 years in the United States, in California, New York, and Missouri. And then in 1976, it was purchased by a Swiss national, Baron Hans Heinrich von Thyssen-Bornemisza. And everybody calls him the Baron in the lower court opinions and the court papers because nobody knows how to pronounce it. And in 1992, the Baron and the Kingdom of Spain together established a new museum in Madrid called the Thyssen-Bornemisza Collection, usually called TBC. And the Baron sold the Pissarro and most of the rest of his collection to TBC. In 1999, 60 years after it was stolen by the Nazis, Claude Cassirer found the painting listed in a TBC catalog. For the next 6 years, he tried to get it back using diplomatic channels and an official petition to Spain, but to no avail. So in 2005, he brought suit against Spain and the TBC in federal court in California, where he had lived for the previous 25 years, alleging various state common law claims like conversion and unlawful possession, and asking both for damages and to get the painting back. That was 2005. This case has been in litigation ever since. In the meantime, it's been up to the Ninth Circuit and back 4 times. Cert has been denied twice. The Kingdom of Spain was dismissed voluntarily, leaving only TBC as the defendant, and Claude died. So it is now being litigated by his heirs, including David Cassirer. The only question left after all of these trips to various courts is whether the claims should be governed by California law or by Spanish law. And they're different. Under California law, a thief can never take or pass on valid title. So the Cassirer family still owns the painting. The Nazis stole it. They didn't have valid title. They couldn't pass valid title on to any of the subsequent purchasers, including TBC. Under Spanish law, however, a purchaser of stolen property can obtain title through essentially adverse possession, as long as the purchaser doesn't have actual knowledge that the property is stolen and as long as it holds the property openly for at least 6 years. And the district court found after a bench trial that both those conditions were met. Although it also found that although TBC didn't actually know that it was stolen, both the Baron and TBC ignored some red flags about the provenance that they maybe should have investigated. But the Supreme Court isn't even deciding whether California or Spanish law applies. Instead, it's deciding how to decide that question. In other words, what choice of law doctrines should govern? Now, if Cassirer had found the painting in a private museum in Spain and sued the owner of that museum or sued that museum in diversity jurisdiction under Section 1332, the answer would have been very easy. Because in 1941, the Supreme Court held in Claxon versus Stenter Manufacturing that a federal court has to apply the choice of law doctrines of the state in which it sits, in this case, California. So California choice of law doctrines would apply. In other words, a federal court has to apply the same choice of law doctrines that a state court would apply in that state. The wrinkle here is that TBC is an instrumentality of a foreign sovereign. Remember, it was established in part by Spain. So TBC is an instrumentality of a foreign sovereign, and the case therefore could not be brought under 1332 diversity jurisdiction, but instead had to be brought under the Foreign Sovereign Immunities Act, or the FSIA. The FSIA does two things that are relevant to this case. First of all, it strips immunity for suits from sovereigns for suits that are brought for expropriation in violation of international law, which is why this case can go forward at all. And second, it confers jurisdiction on federal courts for suits against foreign sovereigns where the sovereign is not immune, again, like this case. What it doesn't do is specify what choice of law doctrines should apply. Now, 4 circuits have held that Claxon answers the question. 4 circuits would say that just as it would apply, just as California choice of law doctrines would apply in a diversity case, California choice of law doctrines would govern this FSIA case. But the Ninth Circuit is different, and it's alone. Ninth Circuit precedent applies federal common law choice of law doctrines to determine which law governs in an FSIA case. And both the district court and the Court of Appeals held that those doctrines dictate applying Spanish law, not California law. The common law choice of law doctrines, by the way, were crafted by the Ninth Circuit in earlier FSIA cases because there's no other circumstance under which federal choice of law doctrines apply to state causes of action. So what it comes down to is the meaning of the Federal Sovereign Immunities Act. Cassirer's main argument comes from the language, which says that when a foreign sovereign is not immune, and I'm now quoting, the foreign state shall be liable in the same manner and to the same extent as a private individual under like circumstances. And Cassirer's argument is because a private gallery that was in possession of this stolen art would be governed by California choice of law doctrines, then so should the TBC. TBC's main argument comes from a sort of a larger context of the FSIA rather than its language, although they have a way to distinguish the language. What TBC argues is that when Congress enacted the FSIA, it took foreign states out of diversity jurisdiction. Before the enactment of the FSIA, foreign states, to the extent that they could be sued at all, the suit was brought under diversity jurisdiction, 1332. And when Congress enacted the FSIA, they instead took foreign states out of diversity jurisdiction and created a new jurisdictional statute, section 1330. And what TBC argues is that both the legislative history and the purpose of the statute make 1330, this new jurisdictional statute, more analogous to federal question jurisdiction under 1331 than to diversity jurisdiction under 1332. So federal law should govern as it does in federal question cases. The TBC also argues that applying federal choice of law doctrines accomplishes the FSIA's goal of creating uniform standards in suits against foreign sovereigns. I think it's going to be either 9-0 or 8-1 in favor of the petitioner. That is, I think the court will rule that the lower courts should have applied California choice of law doctrines. And the reasons I come to this conclusion, there are three. First of all, they did not grant cert in the other four circuits, right? It's 4-1. Second, I think the textual argument is both stronger and more appealing than TBC's contextual argument. And finally, something that the briefs don't play up, but I think may play a pretty big role in it, is that the court has made very clear in prior cases that the cases in which federal common law should govern rather than state law are very few and far between. But there is one last wrinkle. In an abundance of caution, the district court applied both federal common law choice of law doctrines and California choice of law doctrines, and it concluded that both federal choice of law doctrines and California choice of law doctrines both mandated the application of Spanish law. Now, the Ninth Circuit didn't review the holding under California law. That is, the Ninth Circuit did not review the district court's holding that California choice of law doctrines led to the application of Spanish law, because following its own precedent, the Ninth Circuit said you don't even need to look at California choice of law doctrines, you look at federal choice of law doctrines. So the court probably won't decide, the Supreme Court probably won't decide what California's choice of law doctrines demand. They'll remand it to the Ninth Circuit, either to apply California choice of law doctrines or to review the district court's application of California choice of law doctrines. And if I were representing the Cassirers, I would ask the Ninth Circuit to certify that question to the California Supreme Court, because I suspect that the Ninth Circuit, having been reversed on its conclusion that federal choice of law doctrines apply and mandate the application of Spanish law, will simply reaffirm the same result by affirming the district court's finding that California choice of law doctrines also require the application of Spanish law. So I think that ultimately, even if the Cassirers win in the Supreme Court, which I think they will, it will be a Pyrrhic victory.
This concludes the first segment of this episode of SCOTUScast. In the following segment, we'll hear more specific analysis of oral argument.
The justices didn't have very many questions in Tuesday's argument in Cassirer versus Thyssen-Bornemisza Collection Foundation. At stake was ownership of an 1897 Camille Pissarro painting stolen by the Nazis in 1939 and now owned by a Spanish museum. But the actual question before the court was very technical. When a federal court hears state law claims brought under the Foreign Sovereign Immunities Act, or FSIA, should it apply state choice of law doctrines or federal common law choice of law doctrines? 4 circuits use state choice of law rules, but the Ninth Circuit in this case and others used federal common law rules, which it derived from the 50-year-old Second Restatement of Conflict of Laws. The FSIA in Section 1606 provides that in the absence of immunity, a foreign sovereign and its instrumentalities, quote, shall be liable in the same manner and to the same extent as a private individual under like circumstances. And no one disputes that had the defendant been a private museum rather than an instrumentality of the Spanish government, California choice of law doctrines would have applied. Unsurprisingly, then, several justices focused on that language of Section 1606 and the consequences of adopting the Ninth Circuit's position. They directed most of their questions to counsel for the museum and seemed somewhat skeptical of his arguments. Both Justice Kagan and Justice Thomas asked how a sovereign could be treated in the same manner as a private party if a different set of laws applied. As Justice Kagan summarized, what I take 1606 to essentially be saying is, once you've decided that the sovereign immunity doctrines of the FSIA don't apply, the foreign state really isn't very special. And your answer to Justice Thomas was essentially to say, yes, even once sovereign immunity does not apply, the foreign state is extremely special and has to be treated differently. Justice Breyer worried that the museum's approach to choice of law under the FSIA sounds a little complicated. Justice Alito wanted to know who would decide the content of federal common law and how they would do so. When counsel for the museum responded that the courts of appeals would do so in the first instance, with ultimate recourse to the Supreme Court, Justice Alito suggested that doing so involves serious policy concerns. And the Chief Justice suggested that adopting the Ninth Circuit's approach would create the, quote, unusual situation where you're asking the courts to devise their own body of law. But several justices seem to want to focus on the Rules of Decision Act rather than on Section 1606. Justice Alito asked why Cassirer's briefs downplayed the Rules of Decision Act when that statute could lead to a victory. Justice Barrett asked whether the Claxon case, which requires the application of state choice of law rules in diversity cases, was based on the Rules of Decision Act. Some justices also voiced concern about whether applying state choice of law rules might affect federal foreign policy interests. However, they seemed convinced by the response that, first, those concerns could be addressed at the liability stage, and second, that those concerns might arise even in suits against a private foreign entity in diversity cases. As Masha Hansford, arguing for the United States as amicus curiae in support of the petitioner, put it, there's really no silver bullet here of creating FSIA-specific choice of law rules. Both Chief Justice Roberts and Justice Sotomayor explicitly agreed that any foreign policy concerns could be taken into account at a later stage. It thus seems highly likely that the court will rule in favor of Cassirer, sending the case back to the Ninth Circuit for application of California choice of law rules, although there may be some disagreement about whether the holding should rest on Section 1606 or on the Rules of Decision Act. And once the case is remanded, the Ninth Circuit will have several options. It could affirm the district court's ruling that California choice of law rules end up producing the same result, the application of Spanish substantive law, in which case the court will simply reaffirm its own prior ruling in favor of the museum, but on different grounds. Or it could disagree with the district court and find that California choice of law rules dictate the application of California substantive law, which it could either apply itself or direct the district court to apply in the first instance. Either way, the Cassirer family should win. Or it could certify the choice of law question to the California Supreme Court and then proceed accordingly. In short, the family that has been litigating this case for 15 years about a painting stolen more than 80 years ago is unlikely to get that painting back anytime soon, if at all.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.